All right, when the music stops, please find a seat. Good morning. Opening the executive session on House Bill 1013, Representative DeSimone, relative to amending the definition of temporary alimony. And I believe you have an amendment, or somebody has an amendment on 1013?
Not at this time, Mr. Chairman.
Well, this is the time.
We do not have an amendment.
Okay. So would you like to make a motion?
I'd like to make a motion.
Would you like to turn on your microphone? Now
How's
you would
that
like
one?
to make a motion.
Wow, you get me all coordinated, Mr. Chairman. Thank you.
Oh,
I
if
would
my
like-
mother could hear that.
Maybe she does, and you just
Oh.
don't know. I would like to make a motion of ought to pass on House Bill 1013, please.
Oh, and, okay, that's a good start. I like it when we start that way. And would you speak to what we're going to vote on?
As soon as I find it. Kind sir. I think that it's very important for us to realize that in a very difficult situation such as, and I cannot find the bill, I apologize. Do you have it?
And an annotated copy, no less. Look at that,
Oh
huh?
my gosh, I
Isn't
know.
that really great? He runs the city of Manchester.
He
So
does.
he does, yeah.
Thank you, Lord. But I just believe that temporary alimony is a necessity for both men and women who are unfortunately facing divorce, and one or the other is left with little or no income. So a temporary alimony situation, I think, works really well. And this bill will speak to that and give those people who would otherwise suffer financial travesties something to go on. So I would appreciate the support of the committee.
Anyone else? Representative Bickford.
Thank you, Mr. Chairman. As I recall, we've had temporary alimony for some time. What this bill does, I believe, is direct the court to utilize the formula, which I'm not that familiar with. It came in during my 2 times here.
Yeah.
Can you explain a little bit about the formula?
I'm not very well versed on the formula. However, the reason that we wanted to get involved with the formula is because it creates consistency in the court. It gives the court the opportunity to say to all people who come before them, this is the formula, this is what we're allowed to give you, this is what we'll do.
Okay, thank you.
I recall Attorney Markell used the word predictability.
Correct.
Anyone
So-
else? That's your sub? Yeah. Okay.
I was just pointing.
You know, when we sent out for a sub, I wanted a Diet Coke with it.
Yeah. Where's my coffee? Iced coffee.
Well, they weren't very good at getting the information I needed, so,
Mr. Sullivan, is it?
yes.
Yes, welcome.
Welcome.
Thanks.
Any further questions on, or testimony on 1013? Anything anybody else wants to say? Then it has been moved by Representative DeSimone and seconded by Representative Long. The bill is 1013. The motion is ought to pass. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford, Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball is not here at the moment, Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Jared Sullivan.
Yes.
Representative Levesque is not, is here. I see you.
Yes.
Okay. Representative Petrino will be voting yes. Representative Perez is absent. Representative Gregg.
Yes.
Representative Gibbons is absent. Representative Raymond.
Yes.
The motion carries 14, 13-3.
13-3, the motion,
Excuse me,
13-0, yeah,
13-0.
13-0 with 3 absent.
I only had 1 cup of coffee this morning, and I apologize.
See?
3 absent.
It's a strange day when the chair corrects the clerk on a detail. Oh dear, cherish this I am. And Representative DeSimone, you will be writing the committee report.
I shall, Mr. Chairman.
Thank you, and it's due today. All right. This ends the exec session on House Bill 1013, and I open the exec session now on 1269, which is about restraints and all of that. And 1269? I'm going in this order because of people who are here, okay? But thank you. Thank you. That's all right. I'd like to start with a positive motion on this. So I guess that means I'll have to make it. The chair moves ought to pass. Do I have a second? Representative Panic seconds. Discussion. We have some people here. We have someone from the Department of Education to bring a brief clarification. We are not rehearing the bill. We're not so much taking testimony, but since this became more and more complicated as the days marched on, there may need to be a little bit of clarification. So if I could call the person from DOE up, please. You get 5 points, by the way. A lot of people don't do that. Turn on the mic.
Oh,
Unprompted.
well, I wrote it on my hand today, so I kind of.
You belong in education. You know?
I do. I really do. I appreciate that. Thank you. Good morning. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. I'm just here to answer any questions this committee might have in regards to technical assistance. My understanding was that when this bill was heard, I was not present, and there was some information provided about what was available on the department's website. And I really just wanted to clarify what's on our website. That first and foremost, we are in compliance with the restraint and seclusion laws that were passed last session. What the department has on its website currently are 2 technical advisories that were issued in response to the legislative changes that were made last session. The first one was made just based on the 2 bills that were passed, the Senate bill and the corresponding House bill. The second technical advisory was issued based upon questions that we were receiving from the field, some points of clarification as to the interpretation of the new laws. And then most recently, in working with the Department of Health and Human Services, as we were required to do by law, we have issued the restraint and seclusion form. That is a fillable PDF that is available on our website, and we have sent that out to the field. And as I always say, nothing that I ever produce will be perfect. I wish I could say it would be, but we are open to suggestions and feedback from the field. It is really a working document. So we're getting feedback and trying to address any of concerns that we're hearing. So I just wanted to clarify that for this committee. I'm happy to answer any questions. And thank you for your
Any
time.
questions for Attorney Fenton of a clarifying nature? Representative Long, you have a tell, I know when you're going to want a question, you have a tell, I'll explain it later.
Thank you, Mr. Chairman, and thank you for the opportunity. One of the concerns is prior to the use of constraints, immediately after seclusion or as soon as, on line 22, actually, as soon as practical. My issue is with other children in the classroom and being identified. That's somewhat of a worry to DOE?
I think the short answer is yes. In terms of the video being released, that's the bigger concern. We deal with those concerns on a somewhat regular basis. If you recognize that there are a lot of recording devices in hallways, not in classrooms, but in the hallways, that if there is an incident at a school in a hallway, then there presumably would be other children videotaped. And so what the schools will typically do, and I can't speak for every school obviously, but typically they will blur other children's faces or make it so that the only focus is on the particular child or the particular incident, whatever the situation might be. So there are ways to address that concern. I also think that if you think about when restraint and seclusion occur, restraint and seclusion, and I by no means am an expert. I am a lawyer. I'm not from the field. I'll be always the first one to acknowledge that. But I have become somewhat of an expert in just working with the field on this very complicated topic. And what the field will tell you, and I think it's so important for this committee to hear from the field on this topic in particular, it's a challenging area for educators. It really is. Some of the behaviors they are seeing are very, very complex and challenging. This is not a tool that they like to use. It's not a tool that they use on a regular basis, but it is a tool to control dangerous, escalating behavior. And typically it is used once the child has already been removed. They utilize therapeutic intervention, and the statute speaks to that. It doesn't define that term, but it speaks to therapeutic intervention. And so could other children be caught on camera when videotaping it? Yes, they could. That's the reality of it. But typically the child has already been removed to a different area, a separate area. Not necessarily secluded, but removed from that area where the issue is already occurring. So I think it is a smaller likelihood than having cameras in the hallway. But again, my caveat to my testimony is that the people that really know the ins and outs of restraint and seclusion are the amazing educators who are tasked with doing it every day.
Can I get a
Follow-up.
follow-up? Thank you, Mr. Chairman. We did hear from Ms. Rosenberg, who stated that it needed work, particularly with students with special needs and IEPs, because it's emergency only that
Yes.
this will take effect. And she was concerned about even their identity, being out to, to parents who wish to see the recording. Well, the parents wouldn't be an issue. They already know that. But those that wouldn't know that a person with special needs or had an IEP, would you see that problematic?
Just to clarify your question, are you talking about identifying a child who has an
Correct.
IEP or special needs?
Yeah.
Yes. It could be problematic. Anytime you release that information, document that information, absolutely.
Okay.
Yes.
One more for me.
One more.
I mean, it appeared to me that this was a Merrimack issue. I get that. I'm from Manchester, and I asked my district, and the the testimony we heard, my district didn't have those issues. I know somebody testified that there were 5 people standing at an open seclusion door with the child inside. I know you need to get a trusted adult for that child, whomever that may be, whether it's a coach, whether it's somebody not in the schools. So we heard testimony that that wasn't happening. And that was part of this bill, because that wasn't happening, which is already in statute. So do you see this widespread throughout the state?
And to clarify, do I see the need for this?
Yes.
I can't say that I see the need for it. My observations, and again, it really is just my observations. This is a challenging area of the law. I think school districts and special education teachers are struggling to fully comprehend what last year's legislative changes mean. I think it is important to recognize that this is used in an emergency situation. These tools, and they are tools, restraint and seclusion are tools. I don't know of a single educator who looks forward to interacting with a child in this capacity. They are highly trained individuals, and I know that a lot of the schools put a lot of time and effort and resources into ensuring that this is done properly and in accordance with the law, and it's only done in those emergency situations. What I've heard from the field is they're struggling. They're struggling with the changes that were made last year, of fully understanding how to implement them, of understanding how this information is being utilized. It's a challenging area of the law. They want to make sure that they are giving the child what they need to make sure that the child is safe and the people around them are safe. And at the same time, they are so self-aware and conscientious not to violate the law. And so it really is, I think, a very delicate balancing act.
Very good. Thank you.
Representative Panic.
Thank you, Mr. Chairman, for allowing me to ask the question, and thank you for coming in today. Do you feel that this will help reduce the amount of lawsuits against the teachers or maybe another administrator in the school system by having the videos?
I'm not aware of any lawsuits that are occurring. I'm sure they are. I'm just not aware of any. So I don't know if I'm in a position to say whether it would reduce them or increase them. I don't know. I think your question is probably better targeted to the educators who engage in this work directly. I would hesitate to go any further in my testimony that I already have, because I'm not from the field. And I've never engaged in restraint or seclusion of a child. And so when I train in this area, when I work with the field in this area, I'm always the first to admit my deficiencies, that this is not an area that I work in. The irony is my mom was a special educator who did do this work. But I haven't had that personal experience. I go back to my prior testimony. This is an area that educators are very well trained in, but it's hard. It's a hard area, and you're always trying to maintain that delicate balance of having to react in an emergency situation. And I, again, use that word for a purpose. It is an emergency situation to use these tools to calm down a child who is escalating to the point of causing harm to themselves or others, and not wanting their work to be Monday morning quarterbacked, for lack of a better term, or second guessed. I think that's what I'm hearing from the field. I know that doesn't directly answer your question, and I apologize for that. I think it's the best I can do. Thank you.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question, Attorney Fenton. We got a number of emails from parents who wanted to know about their rights to opt out of this kind of surveillance. So parents who are concerned that schools might be, if this passes, if they were videotaping their students, that schools would be using it to make a case on, sending kids out of their local district, or families who felt that this might be a scary and uncomfortable thing for their kids. And so my question is, what do we have that protects a parent's right to opt out? Because currently we have opt-outs in law for like photography and other things. Is there anything in law that would protect those parents who don't want their children to be subjected to this type of surveillance?
It's interesting.
And while you're looking that up, there would not be such a right for the video in the hall suddenly to shut off when that child walks by and shut back and turn back on when the child is passed, would there be? Which is a ridiculous question. I know the answer. No.
I do really well with ridiculous questions, just so you know. So,
You've come to the right place.
well, you're asking the right lawyer. The answer is no, and I'm certainly not aware of anything like that. The opt-out provision that I'm very familiar with is in 186. Hold on. 186. It deals with the surveys. 186.11. Roman numeral 9D. And that deals with non-academic surveys being provided to children. And there's that opt-out provision. So certainly this committee could look at that as some potential guidance. Different, however, a survey given in a calm environment versus videotaping in, again, an emergency situation. But I think that the language in the law, I did hear some murmuring after your question. It's already in that IEP plan, presumably. And the parent can agree to that or not agree to that. I think it's important to recognize that even children who don't have an IEP can sometimes have restraint and seclusion applied. It's not just limited to a certain population. So it might not be addressed in every instance.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. This is actually further to that section.
Okay.
So what I'm reading is, as soon as practicable pursuant to RSA 189:68, blah, blah, each use of seclusion shall be visually and auditorily recorded if such method of recording is included in the student's individualized education program or accommodation plan.
Yep.
My question is, legally, if this is part of a child's IEP, it's an emergency situation. Therefore, there might be an occasion where videoing is not practical or not happening for whatever reason. Would that set the school district up for a lawsuit because that
Was not.
session of restraining, for lack of a better term, was not recorded in an emergency situation? Thank you for answering my question.
Thank you for the question. So you're right. If it's included in the student's IEP plan, could a family, could a parent or guardian file a grievance? Yes. Could they file a lawsuit? Potentially. Certainly, I don't see what the remedy would be for a violation in the law. And that's certainly something this committee could take into consideration. But yes, the way it's written, as soon as practicable, each use of seclusion shall be visually and auditorily recorded, if included in that plan. Yeah.
Representative Bickford.
Thank you, Mr. Chairman. Thank you. The way I'm understanding this is there's an IEP and an accommodation plan which I'm not familiar with what accommodation plan is, by the way. But if it's put in there, I assume it's put in by the parent. in the accommodation or IEP. Would that be correct?
So, thank you for your question. Let me answer the first part, the accommodation. So the accommodation is called a 504 accommodation, and a 504 accommodation can be for a variety of things. It can be if you need additional time to take a test. It can be if you need to be in a quieter area to take a test. I will share with you on a personal note, my son has scoliosis, he has a back brace, and so he has a 504 accommodation plan that allows him to leave the classroom early to go to the nurse's office to take that off, whatever the case may be. It's not an IEP, it's an accommodation, and you'll find a wide variety of accommodations. Going back to the IEP question, the IEP is created with a team, and the team includes the parent voice, guardian voice is a very important part of that. School district, special education teacher, regular education teacher. It is a team of people who create this IEP. In the best of circumstances, everyone is in agreement. However, we have seen at the department that sometimes there is disagreement between those team members as to what is best for that student. So there can be those disagreements. There can be partial consent. There can be no consent to an IEP. But in a perfect situation, the IEP is agreed to by the parent, and that would, of course, include this language.
Okay, so it is voluntary then?
Follow up.
Parents. Yeah.
Voluntary in what sense?
That the parents have agreed to have the cameras. I mean, that's what this is all about, having it during the
That would be part of the IEP meeting. It would be written down in the IEP, and the parent would be able to review that and then sign off on it, agree to it, yes.
okay,
And if they didn't agree to it, they don't have to agree to that portion of it. It
right,
could be signed in what they call partial consent.
yeah. Okay, I think that helps me. Thank you.
You're welcome.
Thank you.
Thank you very much for your time.
I'd like to call Representative Tim. Once again, this is not testimony, this is not a hearing, but because of many needs for clarification, I would like to call the prime sponsor of the bill to do just that, not to redo a hearing, but to clarify a few things that I've heard all kinds of different answers to the same question.
Thank you, Mr. Chairman. Nice to see you all again. Appreciate the opportunity to clarify a few things. First, let me just start out by saying that anyone can sue anyone for any reason. I think we know that. Parents sue the schools, parents sue other parents, parents sue the state. This bill aims to reduce that in a tiny fashion, or at least make those types of claims obviously correct or incorrect, or answer some of the unanswered questions that we may see in the subjective or long or delayed report writing. I mean, how many times have people here been in a little fender bender and the guy says, well, I had the right of way and you claim you had the right of way, and you just wish there was a traffic camera there to prove exactly what happened, because it would put all of that discussion immediately to bed. It's why we have body cameras. It's why we have surveillance in schools now. It's why the governor and council approved $9.8 million specifically for surveillance and access control. It's why in the city of Nashua, they're going to receive $170,000 specifically for surveillance. Right? Schools are on board with this. They know it breeds transparency. They know it's for the children, for the students, and for the teachers. They know that debunking he said, she said is the easiest way to put a stop to it. Representative Long, 1,434 cases is not an isolated Merrimack issue. That's a statewide issue, and it's too often. And if you think for 1 minute it doesn't happen.
Cases for what?
Cases of restraint and seclusion reported in the last full reporting
Thank
year.
you.
It was also from my original testimony. But Representative Long, you commented it's a Merrimack issue. 1,434 cases of restraint and inclusion and seclusion is a statewide issue. Full disclosure, I mentioned before, and so did other testifiers, They mentioned that in some of those cases, that's a multiple student, single student with multiple cases. So individual cases is probably somewhat less than 1,434. But let's cut it in half. Let's cut it in a third. Let's divide it by 5, and it's still too many, if you ask me. And there's still too many unanswered questions. And if you think for a second, it doesn't happen in the Manchester school
I'm going to ask you
systems.
to wrap it up now
Sure.
because it's becoming a rehearing of the testimony.
Agreed. So people act differently when there's a recording. This will protect our most vulnerable children. We have a lot of privacy protections. That's an issue that's come up several times. We have a lot of privacy protections. We have FERPA. We have HIPAA, which doesn't generally apply here because it's a health protection and portability act. So HIPAA doesn't generally apply, although we've heard that sometimes it does. Some claims that it does, but I'll tell you emphatically it does not. So hopefully that answers a few of the questions about how widespread the problem is and how this aims to take a small step to reduce lawsuits, reduce ambiguity, and protect the kids and the teachers equally.
Representative Petrino.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. You did cite a tremendous amount of incidents happening in Merrimack and throughout the state. So is there an implication that when a video is there, those incidences will be reduced, thus implying that there's abuse going on? And the reason why I ask that is because I'm wondering if the real issue isn't that of professional training so that the staff knows how to manage these children appropriately. Because just having a video and seeing what goes on doesn't solve the underlying problem. So either there is deliberate abuse going on and we want to catch these perpetrators, or we are acknowledging that staff is woefully unprepared to deal with these children.
That's an excellent question. In a word, no. The best training tool you have is video. Think about how every sports team gets better. They measure what they want to improve. They observe what they want to improve. And the first thing you do after game day is review the game film to prepare for the next game, right? Everybody knows that video is an excellent teaching tool, for one. So in a word, though, in answer to your question, do I expect that the incidence of restraints and seclusion will dramatically drop? Not necessarily. I think there's a number of issues, mainstreaming of kids, creation of IEPs. There's a whole host of issues. This is a small step to increase transparency and to learn from the issues and learn from the incidents that are currently happening and hopefully make them less and make what happened more clear to all parties, to the superintendent, to the school board, to other parents, right? And to the parents of the children who are secluded and restrained. So that's how I think this will go.
Representative Long.
Thank you, Mr. Chairman, and thank you for the opportunity. I realize how many seclusions there are. However, when I spoke to the Manchester's district, although they are still struggling with what was passed last year, we heard testimony of, for example, I mentioned to the attorney, there was a door open, 5 people there. So the trusted adult, I'm assuming, must be difficult. And I certainly respect the fact that you believe that a film will reduce. I don't. People that are doing harm, a film doesn't get them to not do harm. They lose their job. That's how they're not going to do harm. So I don't believe. I tend to lean towards Ms. Rosenberg when she says that it needs work. I believe that it does need work, and that it's an emergency only. Incidents that we're now going to be filming, I think that makes it more complicated for. I know it makes it more complicated for the Manchester district on getting that. So I don't agree. I see where you agree that it's going to reduce harm. I don't agree that it will reduce harm. I think it'll be more complicated, and I think it will bring more suits.
In the reporting year that we looked at, the most recent complete year, Manchester wasn't in the top 5, nor was Merrimack. The top 5 were different schools that I named previously. I could go back, but I won't repeat them. So, I mean, perhaps we do disagree on whether video is a useful tool, but I think what we can agree on, you mentioned it yourself, harm. We can agree that harm reduction is a good thing, and reducing 1, 2, 5, 100, 500 cases, or at least making it more clear what happened, is a good thing. So for the sake of harm reduction, for the sake of protecting the children and the students who are the children, and the parents and the teachers, so that everybody knows what happened, why not be transparent? The state just issued $9.8 million of grants to help fund this.
Representative, as I was going all through this, and the question of vindication came up, my mind went to vindication of teachers. I have educators in my big family, and sometimes they get accused of harming little Billy when they were trying to calm him down or force him not to hit others. And I would think that any good teacher who does the best he or she can, which in an emergency is the best one can do at the time, might welcome being videoed to demonstrate this kid was wild. And I was trying to prevent gross harm to others. And so therefore, this is what I did. And when the kid said, no, you didn't, look at the tape.
It was one of the first, thank you, Mr. Chairman, for those comments. It was one of the first cases that when we started investigating, some of the other representatives, Representative Mooney, who's an attorney, and I met with some other people outside of the initial constituent group as we were doing research to find out where to place this in statute, how to couple it with the existing statute and what was passed last session. One of the first stories we got was, thank goodness we had video, because the student told his parents that he had been jostled around or thrown into a wall, and they reviewed the hallway videotape. In this case, it was hallway videotape, and thank God they had it. And those teachers were immediately exonerated. There was no lawsuit, and there most certainly would have been if I were that parent and firmly believed that my kid had been assaulted. I probably would have thought about a legal action, but that immediately squashed it. They looked at it, and the child had been led peacefully down the hall, and
I'm going to ask
Fix
the
the
members
problem.
of the committee who are thinking of asking questions, please limit questions to specific technical things where we need clarification. Otherwise, we're going to have a hearing, and we're not supposed to. Representative Patino.
Thank you, Mr. Chairman. Thank you, Representative. I was just wondering if you'd be open to the idea of interim study. And the reason why I asked that is because Maureen Tracy, who did testify, one of the Merrimack parents who came forth, I was looking at an email exchange that she had with some of our committee members, and she took the current bill as proposed, and side by side, she offered suggested amendments, which in my opinion enhanced the bill. I mean, personally, I want the parents to know that we hear their concerns. Just don't think that this particular bill addresses it. So I'm wondering if we can work to improve it. An interim study might be the best way to go.
so thank you for the suggestion. Maureen Tracy, Mrs. Tracy is behind us here, and I think she looks like she has another constituent with her too. I'm not sure. So I did take a look at those suggestions. Those were suggestions that she put together by rewatching some of the testimony, is my understanding, and she can speak for herself. But the bill's ready to go as an initial step as it is. I mean, the nice thing about our RSAs is they're constantly in interim study. Every RSA is in constant scrutiny, review. That's what we do here, right? Last year, we passed 2 bills on this same subject. We could have interim studied those until we could find a way to put them both together or put them together with this issue. I'd say let's take this step now and sure, continue to study it. The chairman may wish to form an ad hoc committee and continue to study and see how it could even be expanded. The one opposition from Karen Rosenberg, she said it didn't go far enough. She wants cameras in every classroom. And we've heard that from a few people. You know, let's put them in every single special classroom. Let's get back to segregating those students with IEPs or the special needs students. Those are all issues for discussion. But for now, this is a limited initial step. So I think for what it is on the face of it, it's very well thought out in terms of its positioning. There was a lot of discussion with legal experts and SAUs, how this would fit in their policy. Is it workable? And then $9.8 million in funding showed up. Not all for surveillance, and some of it's access control and other things, but a huge number of it is. It's like 400 schools that got these fully funded grants.
Without objection, I would like to call the question. Because if the motion on the floor fails, we can have another motion. I'm not asking you to vote against my motion, but I'm just saying this is how it works.
Thank you so much.
Just a clarification,
Yeah, go
if I
ahead.
may.
Yeah, please.
The 9.8 million is not for restraint and seclusion,
Surveillance.
correct?
isn't it?
It's for surveillance.
Correct. So it's not for
let me just
restraint and seclusion. I wanted to be clear on that. It wasn't meant for restraint and seclusion.
No, it's meant
for
for,
surveillance.
but surveillance, audiovisual surveillance can absolutely include those seclusion rooms. So just to clarify, so there's no
I'm clear.
difficulty, not all 9.8 million was designated specifically for surveillance programs. It's about 50-50 as I went through the 4-page list. And Manchester's not on it, by the way. I don't know why they didn't apply for some of those grants. That you did, but just didn't get them, so you're maybe waitlisted. Okay. So it's about 50-50. It's like there'll be 80,000 or 50,000 for surveillance, and then another 50,000 for access control, key card system thing. So it's split up. There's definitely some question as whether you could use either money to cover access and or surveillance of a seclusion room. I certainly think you could, but anyhow. But the money is specifically designated for surveillance and access control. And I think there was one other type of electronic records maybe or something. Piece of it.
Is this specifically a clarification question? Because I would like to move on this as soon as I can. All right, Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. You refer in section 2, as soon as practical pursuant to RSA 18968, each use of seclusion. If I go to RSA 18968, it specifically states no school shall install remote surveillance software.
On a school supplied computing device.
So how are we going to be keeping these records?
So the computing device, in my interpretation, is different, right? It's surveillance. It's like monitoring what websites you're going to and things like that. That's how I would understand that. That's how I read it. A school supplied computing device, right? Surveillance software. It's
Bigger than just putting cameras on kids.
Representative Nelson.
Thank you, Mr. Chairman. I also reluctantly said yes. I agree with Representative Gregg. I agree with Representative Petrino, Representative Long. I would like us to take a look at if this is a training and accountability issue. I think that it would be helpful for us to reach out to people who are experts in this field to get a better idea of how we can help these kids. Thank you.
Before I call on anybody else, would somebody who is much more learned in these things define for us how an interim study actually works? Why the chair recognizes Wednesday Adams. Could you come up and tell us how the interim study process works?
Yes, of course. So folks will plan to get together usually around October, and then the committee can meet as many times as they need to. And I believe that the deadline is the end of October. November 1, I believe, is the deadline. But
It's noticed in the calendar. It's a meeting of the committee.
correct, and you produce a statement of your findings, and regardless of the outcome, because it will be a new biennium, You can recommend for further legislation if you wish. However, regardless of the recommendation, anyone is free to do whatever they like in the upcoming session. But I do find these to be helpful when these bills come up later again, because you can look at the verbiage and what was done in the statement.
Thank you. For Ms. Dyer, yes. Well,
Thank you. Because next year will be a new year and possibly some people will not be coming back. Isn't it true that legislation can be introduced in December? And if we spoke with the current sponsors of the bill, we may be able to introduce legislation that information comes out of the interim study? Thank you.
Representative, did you wish
I did.
to speak? Petrino.
I just wanted to make, thank you, Mr. Chairman. I wanted to make one final point. In the email exchanges that we had with some of the folks who weren't happy with this legislation as proposed, it was mentioned that the state of Maine recently had a similar situation, and a bill was passed which they felt was superior to what was proposed. They mentioned that experts in child care were consulted in drafting that legislation. They saw the Maine now law to be superior, and I, for one, would like to take a look and see what Maine did, and they may actually answer some of our questions.
This could be a wonderful project for a committee researcher. Yes, Representative Ball.
I hear the
No,
Thank you, Chairman
I
Pearson.
was doing term
And
papers.
thank you, my representative next to me, Bertrino, for bringing that up about the Maine law. I would be very interested in also finding out what is in that law that makes it superior. My hope is that it may include cameras that monitor all the classrooms, within the classroom, within any special programs, and within any places where the children calm down areas, wherever they go for that. And my reason for really wanting that, as opposed to just individual cameras on teachers or something, is, again, I go back to that antecedent. And I would just like to say that when these things happen in the general education classroom, there is a negative impact on the other students in the classroom who witness the behaviors. Those children can end up being left emotionally scarred themselves from seeing how a child may be acting out, or how they are dealt with by the teacher. This goes beyond just the one student, that one special education student. It impacts every student who is within the vicinity of the incident. Thank you.
If I know that we are concerned for the children, and if I know that we are advocating for the children, would I not ask somebody from the Office of the Child Advocate to come on up and say something? How is that, huh?
I actually just wanted to offer a resource to what Representative Petrigno said. There is an organization based in Maine called Lives in the Balance.
Say it again.
Lives in the Balance. Dr. Ross Green, who is an expert specifically in school restraint and seclusion, as well as offers an alternate type of training. We work closely with him. We're actually planning on screening his movie in the fall and doing a panel with his organization. They were instrumental in passing that Maine law. So I'm happy to connect whoever wants to with that organization. Ben Johnson is their legislative person's name. I think he's actually sent me a copy of that bill, but they would be a really great resource for your interim study group.
Since we're called Children and Family Law, could we come to the showing?
We would absolutely plan to invite all of you, and perhaps even have someone speak on the panel. NAMI hopefully will be on the panel. But we all in our office watched that movie in the spring and last fall maybe. It's called The Kids We Lose. It's a phenomenal documentary about this very issue of child restraints in schools.
Would there be popcorn?
I will make sure there is.
Thank you. Wow. Thank you. Okay. Seeing no further hands, the bill before us is 1269 relative to the use of child restraints in school. The motion is interim study, moved by Representative Petrino and seconded by Representative Gregg. Will the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Jarvis Sullivan.
Yes.
Representative Levesque.
Yes.
Representative Petrino will vote yes. Representative Perez is absent. Representative Gregg.
Yes.
Representative Gibbons is absent. Representative Raymond.
Yes.
Motion carries 14-0.
Any objection to consent? Since it's I would not think they would say anything. I know it's got a fiscal note, but since the bill that actually passed is to study, I would see no objection. So we can ask for it, and they can always say no. And
Nope.
would you write the blurb, please? There's no need for a negative because we all voted for it. This ends the executive session on House Bill 1269. And, let's see, what is next? Hmm?
No.
Okay.
Mr. Chairman,
Mm-hmm.
are we going to put 1013 on consent?
It's already on consent.
We didn't.
Any objection to 1013 of blessed memory going on consent? Seeing none, it's on consent. Thank you.
Thank you, Mr. Chairman. 69.
Would you like to go next, Representative DeSimone, on 1192?
1192.
Relative to contempt action in domestic relations matters? Your bill?
Mr. Chairman,
Yes.
I handed you an amendment that I would like to introduce on House Bill 1192.
And would you
which-
like to move that amendment?
I do, were they passed around?
No.
Not yet.
Well, I would move it as soon as I get a copy of it.
Well, I mean, they
Sir.
can always say no. Is this a replace all amendment, kinda?
There you go. It does not replace all.
Because the effective date is still,
Correct.
okay, no, it isn't. It's section
Section
4
4.
of only.
It replaces section 4. I would like to move amendment 2024-0914H. We felt
Is
that
moved by Representative DeSimone. Is there a second on the amendment? I will second it so we can now discuss it.
Thank you, Mr. Chairman. I'll give everybody a chance to read it and absorb it. What it does is, after lengthy discussions with the Office of Legislative Services, Jennifer, who is a retired judge,
Really? Wow.
we felt that this amendment is integral to the contempt order. She felt that the entire bill, as do Mr. Markell and I, who authored the bill, it's very serious, a very serious situation in divorce proceedings where people are in domestic relations are constantly in contempt, and there's very little going on in the courts, that the judges have guidance from the legislature, and this provides that. So I'd really like to have this amendment accepted and present the bill on the calendar as amended.
Any discussion or questions to Representative DeSimone? Representative Raymond?
Thank you, Mr. Chairman, and thank you, Representative DeSimone, for taking my question. So, having skimmed this fairly quickly, can you correct me if I'm wrong? It looks to me like the big change is that it makes it so the attorney's fees shall be awarded. The judge won't have the option on that, but the rest of it is still up to judge's discretion regarding incarceration, fines, etc.
Correct.
Okay. Thank you.
Anyone else? The vote is on the amendment 2024-914H to House Bill 1192 FN with the motion to accept the amendment by Representative DeSimone and the second by the chair. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford, Representative Nelson. Representative Nelson?
Out of the room.
Oh, okay. Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Sullivan,
Yes.
Representative Levesque,
Yes.
Representative Petrino will vote yes. Representative Perez is absent. Representative Gregg?
Yes.
Representative Gibbons is absent. Representative Raymond?
No.
Okay, the vote is 12-1.
The chair will entertain a motion on the bill as amended. Representative?
I'd like to make a motion of
OTP.
1192.
And is there a second? Representative Ball would like to second it. Any further discussion? Representative Bickford?
Was it Jennifer Sargent's idea to take away discretion from the judge on the attorney fees? Was it shall award reasonable, attorney fees to the prevailing party?
Doesn't
Or
really take the discretion away. It just gives them the opportunity to specifically say, yes, we shall.
Says shall award reasonable costs. See, under the section in which the party alleges the court finds that a party is in contempt or of court and has failed without just cause to obey an order of decree, the court shall award reasonable costs and attorney fees, which is quite a change in what I think that's probably what Representative Raymond was referring to. There's a loss of discretion there.
Well, there has to be some teeth to the punishment of somebody who is being held in contempt.
Well, it's a matter of
And that's why.
it's a matter of the judge's discretion is what's missing, is taken away here. It's not a matter of punishing. The punishment is there. I just wondered where the idea came from to take away the discretion of the judge.
We didn't see that as taking discretion away. We see it as giving the judge the extra availability. The judge can always make a rule against that or a portion thereof. They shall award something.
It does say something. It says attorney fees shall award.
Yeah, but the fudge factor is the word reasonable. That gives it wide open for what the judge deems to be reasonable, which could be,
Yeah, it just, generally you see it as may to reasonable. And there are reasons for doing one way or the other right.
Shall do reasonable, which means they could award $5, they could award the entire amount. So we're not taking
I think
full
that-
discretion
I think
away.
$5 would be challengeable as a attorney fee.
I get that. I'm just,
Representative Petrino.
Thank you, Mr. Chairman. I'm just wondering if incarceration of a parent is in the best interest of the child. I just wanted some thoughts on that matter. It just seems kind of excessive, in my
Well,
opinion.
it depends upon whether the contempt
Yeah.
situation warrants incarceration. If you have a domestic violence situation and the parent is in contempt of that DV order, these issues are never in the best interest of the child, but we have to keep the children safe. And if this is a domestic violence order, which a contempt order would warrant incarceration, then it unfortunately is in the best interest of the children and the other parent.
Follow up?
Thank you. I hear what you're saying, but again, the way I'm looking at this, this would apply to any violation of the, say, the parenting plan, and it could be something rather simple. And again, I see incarceration there, and it just seems to be like something that would be permitted in all circumstances, regardless of how severe it would be. And I don't know, I just feel uncomfortable with that there. I mean, clearly incarceration is appropriate if there's domestic violence, but in other matters, not so. And again, knowing that your father or your mother's being taken away to jail because they couldn't get along with the other parent for whatever reason, to me would be very traumatic on the child. That's just my thoughts.
Well, I
cannot-
think in that case, it would be the judge's discretion. I don't see a judge putting somebody in jail just because they don't get along with their ex. It would have to be a jailable offense.
I don't see a judge reading this as the sentence stopping at the word incarceration. I see it starting with included but not limited to, and continuing on with fines and reimbursements. I don't see any judge just seeing the word incarceration, one size fits all. I think it's the sharpest tool in the toolbox, almost never to be used, and in the example given, probably should be and would be in the interest of the child. Anyone else? Representative Nelson.
Thank you, Mr. Chairman. I just wanted to elaborate on that a little bit, and I understand where Representative Petrino is coming from. I personally have been involved in a situation where the children were one of the parents was intentionally kidnapping the children, and that happened several times. And the judge actually told that parent that if they took the children again away from the other parent during that parent's parenting time and disappeared without permission for taking them out of state, that parent would be incarcerated. And I think sometimes that is used as a deterrent. I think that is not in the best interest of the children to be kidnapped away from their other parents. So that was just something else I wanted to add to that. Thank you.
Representative Ball.
Thank you, Chairman Pearson, and thank you, Representative Nelson. I agree with you. This amendment does go on to say that it would have to be a history of noncompliance. So it wouldn't just be this person did something once and maybe it wasn't so bad, then they're not going to be subject to an incarceration. But if they're seeing a history of every time the parent gets the child, they're taking the child out of state or somewhere else or not returning the child, then they are clearly demonstrating a total disregard, not just for the parenting plan, but a disregard to New Hampshire law. Thank you.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you all for your comments, because that is the exact intent of the bill. We hear testimony constantly from parents, spouses about this type of action. Something has to be done to cease the action of these people who feel, well, there's no consequences in a court of law, so I'm just not going to follow what the judge tells me to do. There's no consequence, there's no severe consequence. So what's the big deal? I just will do as I please. And that was the intent of this bill in the first place.
In the special committee on the family division of the circuit court's hearings, I think we had 14 hours of testimony from the public. This came up again and again and again. The judge said the other person didn't, nothing happened. Representative Petrino.
Thank you, Mr. Chairman. Mr. Chairman, I just wanted to thank you for your comments that clarified my previous question. It's given me some pause to think and possibly reconsider, not unless other points are brought forth otherwise.
Thank you, sir.
But thank you, I appreciate it.
Representative Bickford.
Thank you, Mr. Chairman. Wasn't this bill introduced because it was in case law already, and it's just a matter of put it into the statutes? And does that still follow through now?
Yes, it's to bring it over to the family statutes so that it gives more clarity to the family court judges.
But if I may, the amendment does not change that, does it?
No,
Okay, that's the answer I'm looking for.
thank you.
If I could.
Yeah.
Yeah, I mean, we are quasi addressing this. We have a bill on a regular calendar Thursday on enforcement of parenting plans. So I just wanted to bring that. So historically, when we put 2 or 3 bills towards one issue, we get complications like we had in the last bill. We pass something and don't let it, and we don't absorb it and add more, it makes it more complicated. So
Could it not be the case that should both bills pass and they're scrutinized to see are there places where there's contradictions, when both bills go over to the Senate, they'll figure that out?
yeah, that could happen, but
I mean,
I know when I
Good.
eat a lot of salad, something's supposed to happen and it doesn't always. So
The point of this bill is actually using the word contempt.
Right.
This is actually putting
make a
the
referral.
contempt in that statute. So this bill will actually give more teeth to the bill that's on the calendar for Thursday. The parenting plan bill doesn't discuss contempt, is what I'm trying to say, Representative Bickford.
Thank you. If I may, you said it gives more teeth, and I don't see, if it's following case law, all we're doing is transferring from case law into the statute books, which means it doesn't give it more teeth, it's just more available, more visible. So,
Okay, so we'll use that term instead.
is that
That's
correct?
okay. Yeah.
Okay.
I am in the process of examining a couple of items in the rules of evidence, which, as you know, I've read 4 times. And in one of the particular cases or rules, the footnotes simply give case law, some of which is mutually contradictory, and all of it taken together is insufficient. And yet, none of the people working with me realized, until we have been doing this job for quite some time, that tucked away somewhere in the laws is the answer to the question on that rule. And therefore, people who quickly go to the rules of evidence and go to that section don't know that. hence the problem. And I mean, I felt so good because I'm not a lawyer, although they're trying to get me to become one. But all these wonderful lawyers didn't see this either. And somebody finally spotted it. And we all looked at each other and said, the names of these people here will never leave this room. So there's a gag order on who all the lawyers were that missed it. But now it's going to be put into rules of evidence from the statute. So I'm defending the point that this is a good idea. Even though there may be case law, it's sure good to get statute where people look.
Yeah, and that's my point. If this is the same as the case law, there's no reason not to just put it in the statute book.
And that's a good thing.
Oh, it is. I brought 2 bills already following the same thing. They
And
just-
all those who shall remain nameless would agree. Yeah. Okay. We ready? The motion before us is House Bill 1192 FN, as amended by Amendment 2024-914H, moved by Representative DeSimone and seconded by the chair. Seconded by Representative Ball. And the clerk, please call the roll.
Chairman Pearson,
Yes.
Representative Long,
No.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Sullivan,
No.
Representative Levesque,
No.
Representative Petrino is going to vote yes. Representative Perez is absent. Representative Gregg. Representative Gibbons is absent. Representative Raymond.
No.
We have 9-5.
And the motion carries 9-5. Representative DeSimone, would you write the committee report, please? And this concludes the executive session on House Bill 1192. And now I open the executive session on House Bill 1659, and the chair is in possession of an amendment to this bill. The amendment is authored by Representative Post, but it shall be presented by Representative DeSimone. That's what my little sticky says. What'd I do? Oh, 2 more. I think.
More of the same.
Yeah, one pager, 2 sides. Do we have enough? Everybody have a copy? Representative DeSimone, I need you to move the amendment and it needs to be seconded so then we can read it and discuss it, okay?
I would like to move amendment number 2024-0921H.
And is there a second? Representative Nelson
A second.
seconds it. Thank you. Now let's take a few minutes to read it.
We all set, Mr. Chairman?
I'm looking around. Before I forget it, you've got these documents that at your places, and so they don't get just tossed or something. They go back to the videoing and restraining and so on. So we may want to keep these because we've got a study session coming up in October. So just don't toss them. Cover looks like this. Yeah, I think we're ready. Representative DeSimone, I did a side-by-side with the original bill and see that the replace all amendment takes out numbers of things and changes a few things around. Would you like to walk us through?
Certainly, Mr. Chairman. If you do the side by side, you'll see that the first section where it talks about unless the court order, okay, so lines 5 through 9 really don't change.
In the amendment.
In the amendment, correct. The amendment also does not. The amendment actually changes from in section 2. The original bill said if the court finds that the parent has without just cause failed to abide by the terms of the parenting schedule, the court shall order additional parenting time to the other parent as compensation for the time lost with the child. She left that in, and I'm not really thrilled about that. But what it does is the amendment deletes section lowercase a, which says shall be of the same type and duration as the parenting time that was denied, or a reasonable approximation thereof. We just felt in discussing this with the representative that if parent A takes the child for 2 years and parent B gets the child back, if you don't allow the child to see parent A for another 2 years, that's only hurting the child. It's not doing anything for the parents. So we asked her to take that out. We had her just say the court shall order the parties to resume the parenting schedule immediately thereafter, according to the original court-ordered parenting plan. So then it does go on, in addition to reasonable attorney fees and costs under RSA 461A, the court may impose a fine of up to $500 for non-compliance with the parenting plan. Again, she wanted it to say each day of non-compliance may be considered a separate offense. We had her take that out.
Some of the objections that came up in the hearing, it
Those
sounds
were
like have
all
been
objections,
addressed in the
Yeah.
replace all amendment.
Yep.
Anyone else? Representative Raymond.
Thank you, Mr. Chairman. I am really struggling with competing philosophies between DCYF and parenting plans. So parenting plans are about the best interest of the child, and that's where the judge's focus is supposed to be. DCYF is about demonstrating whether or not a child has suffered protracted harm or impairment as a result of abuse or neglect. If we now tie withholding parenting time to a finding of abuse or neglect, we're saying to the judge, forget best interests. Now we only want you to make decisions based on whether or not a child has had protracted harm. And so I'm thinking of a situation where DCYF gets a report that a parent is on drugs, right? And there's a concern that the child is not being properly supervised because of the parent's drug habit. It would be very common for a DCYF worker to go out and make a temporary safety plan and say, hey, until we determine whether or not parent B is on drugs at this current moment. We want you to keep the kid here with you, right? So let's send out the police and let's go check it out and make sure it's safe. So parent B might lose 1 day of parenting time. DCYF might go out and find out that parent B either wasn't on drugs or does routinely use drugs, but not during their parenting time. Therefore, it's okay under our state law. That's an unfounded report. Under this, now parent B, who has a drug problem, but it isn't a finding of neglect, has to have compensatory parenting time and all of this other stuff. To me, that just really complicates and confuses the issues. And I can think of dozens of other examples off the top of my head where a DCYF worker, in conjunction typically with law enforcement, might say to a parent when they receive a report, hey, can we do a temporary safety plan? It's Friday afternoon at 3 p.m. We can't interview everybody till Monday. Can you hold the kids this weekend? Because it's in their best interest to not be placed at risk of harm. And now I see us ending up with all of these court dates for parents who are like, well, DCYF unfounded it. Clearly there's no problem. I want my time back. And that's not putting the best interest of the kids first. We already passed a bill this year about false reporting, right? Now we're saying reasonable reports that DCYF is reasonably making efforts to keep kids safe. We're now going to interfere with custody plans. It makes me really uncomfortable, and I think it's going to cause a huge backlog in the court system. And I also don't think that it's letting judges have their discretion to say what's best for kids in these situations.
Representative Long. Thank you, Mr. Chairman. I do also see that, and I also see I'm looking at this as the child being treated as a pawn or a tool to add the time to the other parent. For example, my ex doesn't want me signing up my son for football. I signed him up, but I have that time with him when we practice and play games. So if this was me that for whatever reason I'm not allowing my wife, I'm not sending the child back, she would get extra time with the child, and that would be gone. So I'm looking at this as the disruption to the child. I get the compensation for the parents, but I'm looking at it as the child's. How is the child disrupted? And I think there's avenues with which they will be disrupted. And a $500 fine, where does that go? To the court?
Where do fines go?
Does it go to the other parent that's suffering?
Where do
it's going
fines
to the
normally
court
go?
and get me to pay my child support when I got to pay $500 a day, if I'm ordered.
Anyone else? Representative Ball.
Thank you, Chairman Pearson. When a child is kept away from their parent, it negatively impacts the relationship between the parent and child. So this is not just about the parent losing time. It's the child losing time and ability to continue to build a relationship with their parent. So if in the case that Representative Raymond mentioned, where DCYF might say, well, while we investigate this, we're going to leave it with we're going to keep the child with the other parent for the weekend. I agree that if nothing is found, then make that time up the following weekend. There's no reason to deny the child. I'm not talking about denying the parent. This is denying the child their rightful time with both parents. And I think that we should not be focusing on what the parent is losing, but this bill focuses on what the child is losing, and that's the access to both parents. Thank you.
Representative Nelson.
Thank you, Mr. Chairman. Further to Representative Ball's input, I have had experience being a step parent and also have been privy to other healthy co-parenting situations, and it generally is practice that sometimes a parent will request of the other parent additional time for whatever reason, going away on vacation to visit family or whatnot. And then, then it's an agreement that, the other parent gets a little more time somewhere else. So I don't think that that's unreasonable to have here in this amendment.
Representative Gregg.
I'm concerned with the direction that we continue to keep going in this committee where we pass one bill and then we have another bill that either confuses it or competes with it. We've already passed 1006 through here, which covers most of this. I'm not sure why we're having so many bills that are so different when they come into our committee. And I'm just concerned about the message that we're sending about the functionality of our committee when we continue to do this.
If you think that, believe me, when the chairs meet with 700, 800 bills, where people who mighta, coulda got together ahead of time before they issued a series of overlapping bills, believe me, we agree with you in every committee. And that solves nothing, but here we go. Representative Bickford.
Concerning bills, they have been vetted at Legislative Services, that each one has its own merit. The trouble is that you hear one, but you haven't heard the other one yet, and we pass them before that. We do the next one, so we can weigh in on that. Now, as far as this amendment goes, I like everything in it except for one thing, and I would have liked to have, again, on line 19, not seen shall. The court shall order. I think we can work around it the way it's written, because it doesn't say it has to be the same amount of time. Like, I do like some degree of judicial discretion. Shall usually takes that away. But I think the way it continues to read, order additional parenting time to the other parent as compensation for time lost with the child. Now, there are some parents, they can't make up that time because of their jobs. I'm going to call him a son-in-law. He has two other children, another relationship. If it happens to him, he has to be at work. So he would have to probably turn down that compensatory time. And the way this is written, I'm going to say, I think it's okay. That they could say to the judge, I really can't make that up. We're going to have to find some other way to do it. But in the future, I'd like to see more discretion with the word made for the judges. Thank you.
Also, what some of the chairs try to do is, if we see bills that are very similar, we will try to do them on the same day. But there are a number of reasons why we can't always do that, because like you may remember when Senator Whitley came over, we had a Senator Becky Whitley afternoon, because she had 3 bills, and rather than having her make a special trip 3 times, I put all of hers together. So I'm aware of that, and I try to do that with topics, but sometimes there are things that intervene. But I share the frustration of too many bills and too many overlapping bills.
Well, we used to do more of side-by-sides when we had bills that were like, see, where's the difference? What does what?
Sure.
So keep that in
Okay.
mind.
Thank you. Will do. Anyone else? Representative Sullivan, there's no gag order here on you. I'm not saying you have to speak, but in
Maybe I'll
this
ask a
committee, you
question.
can do anything except make motions. So
Oh, okay.
the chair recognizes Representative Sullivan for
All right, fine.
thinking about doing something.
I actually am curious. I obviously wasn't here for any of the testimony, but what is this goal essentially, to try to prevent people from using children as pawns, or a bad faith parent doing something? Is that the goal? And is that a common problem that needs to be fixed? Like, what? I know that this is, now it's everybody's here's opinion, but like, we don't know what the original sponsor was hoping for. I'm just trying to understand the intent here. Whoever wants to answer it.
Representative Long
Yeah, we hear a
for the
lot.
committee.
That's one of the major issues in this committee. Are parents, kids are being played as pawns. So that is a major issue, and a lot of these bills are looking at attempts to decrease that. So that's what's this about. My opinion, I don't believe it does that. I think it adds to their being used as pawns. But to Representative Bickford's point, it says the court shall order additional parenting time. So the court's gonna order additional parenting time. And what you're thinking is that if I refuse it because I can't do it, then that will be done? Or or do I have to take the added parenting time? It's
Same amount of time, that's what you got on. So I'm saying, I guess the wiggle room, that sentence,
but I mean,
for the justice.
but I'm wondering if this can be interpreted as the parent getting compensated can refuse it. I don't know if they can.
Why not?
Because the judge shall.
Shall
order
be,
it.
well,
So I'm gonna say, yeah, Judge, that order, I'm not gonna accept that order. Yeah, I don't think that flies. You know?
yes, Representative Ball.
Thank you, Chairman Pearson. And to Representative Bickford's point, I actually like the word shall in there. I think that using the word may makes it a crapshoot. It's like, well, it's 50-50. We don't know which way the judge is going to go, so I'm going to just try it. Let's see. But the word shall kind of puts a pause on that to say, I might have to pay for this decision of withholding my children from, just to be mean. I'm going to withhold the child. It doesn't say the time is going to be 1-to-1. It just says that he shall order the extra time. And I'm sure that the parent is sitting there. They can actually, when this comes up, can say, I don't have time, or perhaps they would just rather have an extra week. This reminds me of military situations when a person is deployed. Upon their return, in many parenting plans, upon their return, they get the child for a week. Even though they've been deployed for 6 months or a year, they get a week vacation, like one solid week with the child, to make up for the time that they've lost with their child. And that's, it's a different situation, but I see it as being the same, that when the child is taken, it may not be a 1-to-1 return, but there needs to be somehow that parent gets a little bit of extra time to reconnect with their child and bond with them.
The motion before us is on the amendment 2024-0921H to House Bill 1659 FN. The amendment was moved by Representative DeSimone and seconded by Representative Nelson. Would the clerk please call the roll on the amendment?
Chairman Pearson,
Yes.
Representative Long,
No,
Representative DeSimone,
Yes.
Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Sullivan. Representative Levesque.
No.
Representative Petrino will be voting no. Representative Perez is absent. Representative Gregg. Representative Gibbons is absent. Representative Raymond.
No.
Motion passes 8-6 with 2 absent.
Chair will now entertain a subsequent motion. Representative DeSimone? And second? I saw Representative Ball's hand first. OTPA, any further discussion? The motion before us is ought to pass on House Bill 1659 FN as amended by Amendment 2024-0921H ought to pass as amended, moved by Representative DeSimone, seconded by Representative Ball. The clerk, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
no,
Representative DeSimone.
Yes.
Representative Bickford. Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Sullivan.
No.
Representative Levesque.
No.
Representative Petrino will vote no. Representative Perez is absent. Representative Gregg. Representative Gibbons is absent. Representative Raymond. Motion passes 8-6.
The motion passes as amended. House Bill 1659 passes 8-6. Representative DeSimone, would you care to write the committee report? Unless there's somebody who would like to help the soon-to-be Town of Atkinson tax collector emerita with her crushing load of committee reports.
Yeah, I could write the majority report on that.
I don't think so.
Oh, thanks. I'm trying to help you. I'm trying to help you.
With all of your duties keeping Manchester in order, you would undertake this task. And with that, the exec session on 1659 is adjourned, and so is this. And because you've all been so good and you've worked so hard, this committee will reconvene when the Senate sends us things in crossover. You have next Tuesday off.
That is fantastic, huh? I thought we were done with our bills.
Yeah.
Awesome.
Did you know that Representative Gibbons wasn't